All right, you're welcome back. You can tell we've just stepped into the chamber. You know, marriage carries, several legal implications with regards to money, to debt, to property. And so if you enter into such a contract, if you enter into marriage, exactly what is yours, exactly what property belongs to you as an individual, and then exactly what do you have to share with your spouse, especially when the marriage is terminated or dissolved. What happens if you want to split the property? We're discussing spousal property rights, and my guest is Madam Irene Osebon. So she's a private legal practitioner. Madam Irene, you're welcome.
Thank you.
So what do the law say about spousal property rights? I remember seeing an article in 2013 about Parliament, in fact, Cabinet approving the bill, the spousal property rights bill, but it was yet to be forwarded to Parliament, and then for the steps to take place. What has happened? What has become of this?
That bill is yet to be passed by Parliament.
Yeah.
But yes,
wow.
It's yet to be passed. But having said that, that's not to say there are no laws that regulate spousal property rights.
Okay.
If we could start with the Constitution.
Okay.
Article 22 says spouses have equal access to property jointly acquired during the marriage, during the pendency of the marriage.
Okay.
And upon divorce, they have equitable distribution of the property. Apart from the Constitution, there are other provisions. So, for instance, the Matrimonial Causes Act, sections 19 and 20, gives the couples who are divorcing, you have the right to apply for financial provision, and you also have a right to property settlement. If we also look at, say, the Wills Act, for instance, if a spouse passes away and leaves a will, section 13 says that within 3 years of the grant of probate, for instance, a dependent, i.e. a wife or a child under 18 could apply to the court for reasonable settlement if reasonable provision wasn't made within the will for that person. And of course, yes, so apart from the spousal property rights that hasn't been passed, there are other laws that regulate the sharing.
Because I know couples actually fought over wedding gifts
or 60-40 or what have you. It's decided on a case-by-case basis.
Okay.
But the principle is that the equality is equity principle is what is being used by the courts, and all the case law now just get up and go, because I'm married to you, I'm entitled to A and B.
Right.
That is not how the law works.
Yes. But there are situations when, especially elsewhere in the US, in DC for instance, you'd have couples who don't wish to be married, but they want to stay together. They register as domestic partners. I presume we don't have anything like that yet?
Unfortunately, no, we don't. That is why one of the reasons the spousal property rights bill probably needs to be looked at again, because it
will touch on situations like that.
There are provisions that gave they call it cohabitees, people that hold themselves out as being they are not husband and wife per se, but they are a couple together. If you've done so for 5 years, I'm sure if you are with somebody for 5 years, you would acquire property together. You would do things together.
Yeah.
So that, as the law stands, there is no protection for people like that.
That's unfortunate, because then it means that only a marriage license would grant one access to splitting the property. That's sad.
Exactly. But then again, seeing as this is, there's situations that a lot of people are not aware of, that this is the state of the law. If you are living with a man and the man is not your husband, or if you are living with a woman and the woman is not your wife, you really, if you acquire assets during your union together, the law says that you have to be a spouse. If you are living together and you are not married, you are not a spouse. So
but how about entering, and you find that this is widely gaining traction, entering into a prenuptial agreement, for instance, clearly determining what goes to you and what goes to the other, God forbid, knock on wood, if there's a termination of the marriage. Is there a case where the court would overrule that prenup?
And again, prenups is a pretty tricky situation. I'm not sure, it's not even really enforceable in our courts. Yes. But if you look at it from the side of it being a contract, then it would have to meet all the requirements of a legal contract anyway. And that is also one of the things in the spousal property rights bill that probably will be the reason why we may need to look at it again, because it gives cohabitees or even people intending to marry the opportunity to have marital agreements where they would be able to have the frank conversation and enter into a contract, decide this is how we want our property to be managed, or this is how we want to regulate our property during the pendency of this union. And of course the bill has certain mechanisms, like you have to have independent legal advice. It is subject to stringent scrutiny, and once that is done, then it would be given effect. But again, this is just a bill at the moment, so it's still not the law.
I imagine there must be cases where there's a conflict of laws. For instance, you'd have an American man getting married to a Ghanaian woman in the US, so they live there for a couple of years, then relocate to Ghana, and then a few years later the relationship hits the rocks. In this, and of course there's some property acquired by both. So in such a situation, what would determine the split or the sharing of the property? American laws or Ghanaian laws?
Again, it's hard to speculate, but it depends on
well, as it stands now, what?
It depends on where you file for. If you file for divorce in Ghana and you are living in Ghana, you are resident in Ghana, it will be the Ghanaian laws, even though the marriage was contracted in the States.
What happens to property acquired in the States then?
Again, if there is the Ghanaian courts deciding on the issue of what happens to their property, it will be our laws that will determine the split, the divide, or the how the assets are split.
Okay, so in the event that the deceased, or well, because there's death also resulting in this, so in the event that the deceased had children prior to that relationship, what happens? Let's use
without a will is the intestate succession law, PNDC law 111, that would kick in, and it makes provision for a spouse if you were married to the man and children. So it would be that law that kicks in.
And if he died with a will, but the will does not favor the children, so to speak. I've heard people saying they're going to contest the will.
Yes, you can. There's the Wills Act, Section 13. It gives a spouse or children under 18 the right to apply to the court within 3 years from the grant of probate to apply for reasonable provision under a will, and with reasonable provision within the 3-year period. So if a man dies, even with a will, and the will, you feel it's not the provision made for you, or there was no provision made for you, or the provision made is inadequate or reasonable, and you go to court, if the court will look at certain circumstances, that they will make provision for you depending on what they deem to be just and fair.
Back to domestic partners who register elsewhere without necessarily getting married. My director keeps, reminding me to ask you that question. I think he's been living with someone for a while and thinks that, when the relationship hits the rocks, he may not get anything. But you hinted that the new bill actually seeks to cover such people.
But it is
if you've lived cohabited for about 5 years or more, you automatically become a legal partner.
It gives you the opportunities to be able to get something, but don't forget that it is just a bill as it is. Until it is passed as law, it is not the law. So as the law stands now, people that are cohabiting are just cohabitees, and there is no protection.
As it stands now.
As it stands, yes.
Okay. But of course, you've seen tenets of the bill and what it seeks to do, how it would protect such people who are domestic partners.
Yes, definitely. I think there are aspects in there that are really worth looking at. But having said that, it would change the way property rights and as it is, property laws
but then what explains the delay?
I really cannot say. That is for Parliament to pass, because well and truly, the 1992 Constitution came into effect 7 January 1993. And the constitutional provision says Parliament enjoins Parliament to pass an enactment that will regulate the property rights of spouses. So really, our Parliament hasn't got an excuse why this law or some form of law hasn't been passed in fulfillment of that constitutional requirement.
So, presently, how about women who find themselves in polygamous marriages? How are they protected?
They are still protected. Customary marriage, which is potentially polygamous, is recognized under our law. So they have the same protection, the same entitlement as any other marriage. There's currently, we have the marriage under the ordinance, what we normally call a wedding, whereas the customary marriage, there's a marriage under the Mohammedan law. It's all recognized as valid marriages under the laws of Ghana. Therefore, if you are in a polygamous marriage or a potentially polygamous marriage, you still have the same protection. You can still go to court and assert your rights when there's a dissolution, when there's a death. So they are still afforded the same protection. For me, I think the main issue is that most people are not aware of the kind of protection the law affords them and what they can possibly do in order to get what is rightfully theirs when there's a death or when there's a separation. So perhaps we probably have, the societal groups has need to look a lot more at educating
because
people.
You find a lot of women disadvantaged in the event that the spouse passes on or the marriage is terminated.
Exactly.
That's terrible. Anyway, so is there any case where you, lawyer Irene, would advise a couple before marrying to enter into a prenuptial agreement? Other cases you would actually recommend that?
It won't be a prenuptial agreement, but I would say that before people get married, it's important to have the conversation as to how you want your property, the ownership of your property. And even during the marriage is also important, because the assumption is that if you are with somebody and you acquire A or acquire B, you whilst the union is good and the going is good, you will think it's all yours together. But relationships break down.
Sadly, but yes.
Exactly, which is the reality. Relationships break down. So it's important that people start to think about how, if I'm acquiring this house, if my husband is acquiring that house, what is the ownership? How do we want the whose name is on the document? Because a lot of the cases you realize that it's not so much the person hasn't contributed, but when the relationship breaks down, one person feels as though my name is on this document. I probably did A, B, C to acquire it. You did E and F, but it wasn't enough. Therefore, it's mine. So it's the conversation, the awareness, and the education as to how people properties acquired should be owned. So what if, and this is a good question, what if the property in question is registered or has another name on the title? For instance, your husband puts his sister's name on the title when you both know he built it during the course of the marriage. The question is, why would you sit down for your husband? Well, because you didn't know. And of course, a lot of men do a lot of these things behind the women. Can I just say, it's not just the men, because these days, a lot more women are, exactly. Women have been vulnerable for so long. It's true. But a lot more women are being empowered. We also hold property. So maybe perhaps the men would also so let's answer that. What if? Yeah, what if? I mean, as I said, it's a question of facts. If you go to, you institute legal action and you go to court, yes, the property is in the name of his sister. The question is, when did he acquire the property? How did he acquire the property? What was my contribution in acquiring that particular property? Unfortunately, this is where a lot of women cannot prove what their contribution was. It's a question of facts. And if you can go to court and say, yes, my husband acquired this land 2 years after we entered into the union. Yes, he bought it in the name of his sister for A or B reasons. But during the pendency of the marriage, we built this house. I did the supervision. I was cooking for the workers. I provided the money for the painting of the house. I mean, sometimes it's the little things that we probably overlook, which you can't prove. I mean, you don't. I mean, once you've got evidence, that's the thing, though. It's evidence based. I mean, you don't have to physically have a paper. Because when you go to court, sometimes it's oral evidence as well as documentary, and you have witnesses also. So you would have people that could attest to it. We have to wrap up now, but there's one thing we didn't touch on. We're discussing acquiring property and splitting, but there's also the situation where they can incur debts. Of course. And their losses, which also must be split between the two. Certainly. If you want the assets of the man split with you, or you want your fair share, it stands to reason that you'd have your fair share of his debts also. Terrible, but well, it's a reality, isn't it? Thank you, Irene Osei-Bosu. Thank you. Is a private legal practitioner. My director keeps saying funny things. Jonathan, just get married, okay, and get the experience.